This segment is sponsored by Willis Spangler Starling.
Now let's introduce you to an attorney whose company specializes in help for those who have experienced problems in the workplace.
I spoke to one of the attorneys at Willis Spangler Starling, where they offer a full range of legal services to help you navigate through issues affecting your livelihood and your life. Here's more from Attorney Jason Starling. If you suffer from a certain condition or you have an injury that stops you from doing your job properly, your employer may be required to make certain accommodations for you. So today, to talk about all your rights, we're back at Willis Spangler Starling to talk to Jason Starling. How are you doing, sir?
Great, how are you doing?
Good. So Jason, what type of law do you focus on here at the firm?
Sure, I focus on labor and employment law.
Okay.
And simply put, employment law is anything dealing with employee-employer relationship, and labor law focuses on the union-employer relationship.
And when it comes to the term disability, I think a lot of people have an idea of what that means, but in relation to your work and your employment environment, what does it mean and what falls under that category?
Sure, so the definition of disability was expanded quite a bit in 2008.
Okay.
And the definition of disability can encompass anything from what we normally think of as disabilities, like blindness, deafness, an amputation of a limb, for instance, to things as routine and common as your workplace injury, like a sprain, strain, or a rotator cuff tear, things that we wouldn't normally think of as disabilities, but do in fact qualify under law.
And what type of accommodations does your employer have to make for you?
Sure, so the term accommodation is really flexible.
Okay.
So under the law, if you have a disability and you request an accommodation from your employer, it could be something like a leave of absence to treat and recover from the disability.
Okay.
It could be some assistance at work to ameliorate the effects of the disability. So if, for instance, you're blind, it may be that you have a voice activated dictation system or something along those lines. If you have something that makes it difficult for you to sit, it could be providing you a standing desk from which to work. So it runs the gamut, and really under the law, employers and employees have to work together in what's called the interactive process.
Okay.
And explore potential accommodations and see what might allow the employee to continue to work and maintain his or her job.
Now, what happens if an employer isn't willing to make those accommodations, and even worse, you get fired because of it?
Well, sure. So they might be breaking the law.
Okay.
It just depends. So an employer has an obligation to provide an accommodation that is reasonable. And what is reasonable is really an accommodation that does not pose an undue burden or hardship on the employer, or expense, really. And that legal term, like anything in the law, is ambiguous.
Okay.
It really depends on the facts and circumstances. So what might be an undue burden to a small employer of 10 employees may be totally different than a large multinational corporation with 1,000 employees. So it really depends on your particular facts and circumstances. So you may have a claim, you may not.
At what point should people find a specialized attorney like yourself?
Well, if you're in this process and you think you have a disability and you've requested some help from your employer and asked for an accommodation, and your employer is resisting that, or you're feeling like you're being forced out, or they're ready to get rid of you, that's the time at which you might want to seek help from an attorney. Okay. There are things we can do perhaps to help you in the process that might avoid you getting fired. It depends on the employer. And maybe the employer's committed to firing you because they don't want to accommodate your disability. And then if you do get fired, you might have a claim, and certainly should talk to an attorney.
Right. And what if people can't afford it, Jason?
So on the plaintiff side, representing employees, we typically don't bill hourly, which is what they do on the other side, representing employers. So we work on what's called a contingency fee.
Oh, that's great.
So we don't charge you anything out of pocket. You only have to pay us if we recover some amount of money for you, and that's one of the great things about contingency fees.
That's fantastic. So if people, they might be injured already, or they're having something with their job that they're not able to do their job, what's the first step they need to take to get a free consultation?
So sure, you can obviously go and visit our website.
Yep.
That's a very easy tool to use. The other way to do it is just call us. Call our front desk, let them know what's going on, what's happening in your particular situation. They'll know to route it to our employment team, and we'll be able to set up a phone consultation with me where I can explore with you the facts of your case and whether you might have a claim.
Well, Jason, thank you so much for sharing this today.
Appreciate it. Thank you so much.
Now, if you're suffering from an injury and you need those accommodations for your job, contact the team today by visiting our website at willisattorneys.com.